Good day, everyone. We are starting our journey into legal services. To start with, Chapter 1 focuses on the legal profession and regulatory framework in our SQE1 window series. So, it's exciting that you will be joining legal profession in England and Wales. Uh, don't roll your eyes just yet. We shall cover solicitors, barristers, notaries, legal executive, and even paralegals, the unsung heroes who keep the legal machine running. Think of this as a guide tour without the uncomfortable tour bus seats. So we'll try to just cover briefly about all of them, that how they work. So what is the structure of legal profession? The legal profession is neatly divided into two main campuses, solicitors and barristers. Think of them as tea and biscuits. Different but often together. Solicitors are regulated by Law Society through the SRA, while barristers have the Bar Council keeping them in check, they have their own system of check and balance. Then we have notaries, legal executives, and paralegals, each with their own works and duties. Understanding this structure is key because in law, knowing who does what can save you from courtroom catastrophe. So, what are solicitor and how they work? Solicitors are, of course, like we are going to become part of this family. Legal advisors, that one who speaks directly to clients and makes legal smarts with a dash of diplomacy. So they can appear in lower courts on their own and with extra training in high courts, like higher courts. Nowadays, you might even find them in companies, governments, or the courts themselves. The Law Society protects and promotes them, while the SRA ensures they don't go rogue. And if they dabble in finance, the FCA will have an eye on them because we all need someone to stop lawyers from accidentally selling dodgy investment. Say, what are barristers? They are the specialists. Think of them as the Wimbledon champions of advocacy. They provide expert advice, appear in court, and have deep knowledge of their field. They can be instructed directly by clients, but more often through solicitors. About 10% are King's Counsel, a prestigious title obtained after surviving a process that's very hard, very tough. Don't forget the cab rank rule. Barristers must accept cases in their specialty on a first come, first served basis, no matter how much they dislike the client or the case. It's like being forced to serve a plate of Brussels sprouts. It's just part of the job. They need to do it, even they don't like it. Now for the sporting cost. Notaries authenticate and certify documents like legal librarians with ink and stamp. Then we got chartered legal executives, and they are specialists who can do much of what solicitors do, and sometimes even take on restricted advocacy. Paralegals, my favorite, busy bees in a law firm, taking operations in their hand, handling legal work without needing a law degree because they shadow solicitors at some point and they work under their guidance. So the Legal Services Act 2007 shook things up. Its goal to make legal services competitive, consumer friendly, slightly less terrifying. It introduced ABS and LLBs, allowing outside ownership and multidisciplinary practices. And if a client isn't happy, they can knock on the legal ombudsman's door. The ombudsman's role is basically to to referee disputes. Think less red cards in football, more let's find a fair solution. So it's not red card, it's fair solution for both parties. Remember, clients usually give the solicitor 8 weeks to fix the problem before involving the ombudsman. It can be tough for the solicitors. So, yeah. So, reserved legal activities, very important. Sometimes those are tested in your SQE. So, reserved legal activities are the VIP section of law. Only authorized people get in, like you will be getting in. These are six. These are six, like in total: right of audience, conduct of litigation, reserved instrument activities, probate activities, notarial activities, and administration of oaths. Exemptions exist, so sometimes someone can sneak into the VIP area under supervision or court direction. Think of it as sneaking into a posh garden party, allowed if you are with the host, Mackenzie friend, and many other things. So that's reserved legal activities. If any of them appears there, stay away. Someone who is not authorized cannot work in these areas. So what are unreserved legal activities? They are the open access buffet. Anyone can perform them. Mostly like it is general legal advice, will writing, and employment advice, like kind of like it falls under. While no formal authorization is needed, professional standards may still apply. Freelance solicitors have to be careful. They can do unreserved work without insurance, but if they offer reserved services to the public, they must have adequate professional indemnity insurance, basically protection against, oops, I messed up. So at that point, like they should have. And what is professional indemnity insurance? It is a safety net for solicitors. In private practice, they are like, it covers civil liability claims arising from their work. Minimum cover is £2 million per claim. 3 million if your firm has limited liability, and freelancer only needed if doing reserved legal activity or reserved work. If a firm can't get insurance, they get a 30-day extended indemnity period to sort it out, followed by 60 days. And in that 60 days, they have time, and afterward it will finish. Think of it like a probationary period before being allowed to fully rejoin the legal party. So, to sum up the key concept in it, so quick recap I will give you. So, solicitors and barristers are the main branches supported by notaries. Legal executives and paralegals. Regulation come through SRA, Law Society, Bar Council, and Legal Services Board. Reserved legal activities are VIP only. Unreserved activities are open to anyone. And yes, professional indemnity insurance is not optional, it is mandatory. Keep this framework in mind. It will help you navigate through your exam questions. And my favorite, tips and pitfalls. We got it, So know your regulator. Who works with SRA, under SRA, that's solicitors, law societies, solicitors, bar councils, barristers, legal services board, and then memorize reserved versus unreserved legal activities. Like you need to understand, good understanding of professional indemnity insurance as well. So common pitfalls are confusing right of audience with conduct of litigation, or thinking unreserved work need authorization. And finally, don't panic. The exam does not bite, though some question might give you a tiny nudge. But if you just read it carefully, reading carefully will give you half of the answer and half is common sense. And I wish you all the best. Ta-da!